Steve Halbrook, a Second Amendment attorney and scholar, joins us on the program right now. Steve, thank you, sir, for your time.
Looks like it's part two of Abramski, huh?
Yeah, absolutely. So the Supreme Court decision earlier this week, what does this decision mean for gun owners who may, for instance, buy a firearm for a gift for somebody? Something that the firearm for a gift for somebody. Something that the ATF has a rule on, and they say it's okay to do that. But does the Abramski decision throw some of these long-standing ATF rules into doubt or uncertainty?
I don't think so, Cam, and here's why. The majority decision written by Justice Kagan admits that there's a so-called secondary market where the individuals can transfer firearms without going through dealers. The idea that a gift is one transaction in that regard was not challenged. In his dissenting opinion, Justice Scalia lists three items that are not challenged that can still occur, and one is gift, two is a raffle, and three is to buy a gun with the idea that eventually you might resell it. Although there's a Fifth Circuit decision where a gentleman did that and was held to be in violation. And then there's a fourth thing I want to mention that the listeners will remember, but in a different context. When the NRA went to court to challenge the ban on sales by a dealer to minors of handguns, persons in the 18 to 20-year-old age group, the government argued and the court held that it's okay for a parent to buy a gun for a minor. And that was one of the reasons given as to why this is not a burden on Second Amendment rights, that parents can buy guns for minors. And in fact, they even recall that Congressman Dodd in 1968 made that very statement when that provision was put into law about sales to minors, prohibiting them, that a parent could still do that.
Okay. So then again, I guess the next question would be then, Steve, with Justice Kennedy, being the swing vote in this case, Justice Kennedy signed with a majority in the Heller McDonald decisions as well. Can we read anything into this as far as the court and right to carry?
I'd be very careful about doing that, although this was statutory interpretation. It was not a Second Amendment issue that was not raised. And the court, in fact, in the Heller case, you'll recall, said that commercial regulations don't violate the Second Amendment just as a general matter. So this had more to do with the interpretation of the statute. Now, it's a criminal law, and what I find ironic is that the so-called liberals on the court, many times, if the criminal law is ambiguous, they interpret it as they should, strictly against the government, because the government has to give you fair notice of what's illegal. So in this case, if you read Justice Scalia's dissent, it's very clear that there's an ambiguity here, and the language should have been construed on behalf of the defendant. Justice Kennedy is not known for being particularly astute in terms of criminal law issues, and so maybe that issue didn't appeal to him, the fact that where there's an ambiguity in a criminal law that the so-called rule of lenity applies, you interpret the law strictly against the government. But the liberals frequently do latch on to that rule and other kinds of criminal laws that they're construing, just not gun laws so much. So in this case, it's just difficult to read a particular justice like Justice Kennedy in terms of what he may or may not do in terms of if Peruta made it to the court, the right to carry issue.
Okay. All right. Listen, Steve, we are almost out of time, sir, but thank you very much for coming on the program, and I look forward to talking to you again very soon.
Okay. Thank you for having me, Cam. You take care.